My name is Jessica Ritchie, and I am a Research Associate with the School of Criminology at the University of Leicester. This presentation is going to look at DNA evidence in Kenyan criminal courts and look at how the new self-examination vaginal swabs can be used. The presentation is going to cover a number of key factors. Firstly, we're going to look at DNA profiles and evidence, then look at sexual gender-based violence in low-resource settings. We're going to look at the kits for self-examination in greater detail and consider how these are able to provide improvements to the current process in Kenya. Then we're going to look at the collection and analysis in greater detail and consider how the evidence can be used in court and some of the considerations to this process. Finally, we will look at a couple of scenarios just to contextualize some of the things that we've spoken about. Now, DNA evidence is considered the gold standard of forensic evidence, and this is because there is a lot of research internationally to support the claims of what DNA evidence can do. DNA can be obtained from a number of different biological samples now, and this includes blood, semen, and saliva. And the DNA can be obtained from very small samples as well. Now, DNA profiles have been found to be unique to the individual, and this means when we've got a comparison sample, we're able to compare to a profile we have obtained and analyzed to decide whether or not it matches the profile we have available. Now, if you look at the example on the screen at the moment, we can see on the left-hand side that sometimes the expectation about where DNA is and how complex it is can sometimes be underestimated. What we see on the right-hand side is more the reality of the situation. DNA is everywhere and is transferred very easily through bodily fluids, through the shedding of skin cells, through talking and coughing and even sneezing. So this means that when we are having a crime scene, it's really important that the police and crime scene investigators are able to get in there very quickly to ensure the crime scene itself does not change because there's so many people coming into it and through the passage of time. Now, where DNA samples are found is highly probative to a case. So if we look at the situation here, if we say we have a residential home and we know that sexual violence has occurred between two persons that are known to each other, that we know that they live together in this location, then if we do a collection and analysis of samples within the space, it would be expected that we would actually find the suspect's DNA in this room. And as a consequence, that's not going to be very probative in the case. However, if we do a vaginal swab and we know the perpetrator has said that no penetrative sex or rape has occurred, we're able to obtain a profile that matches the suspect, and the suspect has alleged that none of this contact has occurred, then we're going to have quite probative evidence in this situation, and this helps support and corroborate the account that the survivor has provided. So what is DNA evidence able to do and not do? It's important to keep in mind that DNA evidence is only one piece of an entire investigation. So it's really important that police continue to do an investigation which goes beyond just the DNA evidence. It is not appropriate to convict someone just on DNA evidence because it's only able to provide circumstantial identification evidence. Now, what this means is that we're able to identify a suspect, but we're not able to prove or show that they actually committed the offence with just their DNA being present. Now, where we find DNA is able to provide us that probative value that we talked about in the previous example. So if we have a vaginal swab and we were to find a suspect's DNA on the vaginal swab when they allege that contact has not occurred, then that's going to be very probative for the case. Now, DNA evidence is able to provide both exculpatory and inculpatory evidence, and this means that we're able to both exclude or include a suspect in a case. DNA evidence is able to corroborate the account the survivor has provided, but it's still really important to consider that DNA evidence is not infallible. It's not perfect, and we can make mistakes and they can occur along the way. And we're going to talk through some of these situations and how they can be avoided by using these new kits that have been developed. Also, DNA can be obtained through intimate and non-intimate samples, and what we mean by this is that a buccal swab, one that is taken from the mouth, is considered a non-intimate sample, whereas a vaginal swab is considered to be an intimate sample. So, sexual gender-based violence in low-resource settings is an issue. Now, many women across the world, regardless of whether they're in a low-resource setting or not, will often experience sexual gender-based violence by an intimate partner or non-partner at some point in their life. There are a lot of physical and psychological consequences of rape or sexual violence on survivors, and it is one of the most underreported crimes. It is also one of the least successful in prosecutions, and this contributes to a culture of impunity for sexual violence. As a result, there is no real deterrence to reduce offending. Now, sexual gender-based violence is difficult to investigate and prosecute in any country, but it's made even more difficult in low-resource environments. Now, this includes developing countries, remote geographic locations, conflict and post-conflict affected regions, and displaced communities, because there is a lack of medical facilities, equipment, and resources generally available. DNA is able to provide significant probative value in sexual violence cases. It's able to show that sexual contact has occurred between two persons or more. Now, this is particularly useful when we don't know who the suspect is in the case, and with offences that involve children, whether or not the perpetrator is known or unknown is irrelevant to the situation, as a child cannot consent. So DNA is able to prove that sexual contact has occurred between the child and the perpetrator or perpetrators. Now, investigating sexual violence is made more difficult in Kenya because there are a number of critical limitations. Now, these include the chain of custody of evidence, so it's really important that we know where the evidence was collected, where it has gone, and who has touched it, and who has been involved in the process. We also need to make sure that we have timely collection of samples from survivors. The longer we wait to collect a sample, the more likely the DNA will degrade through the passage of time. Now, it is important once we've collected the sample that we preserve the DNA evidence, because if we don't, we can't actually analyze it, and then it cannot be used in an investigation or prosecution. Now, the current forensic medical examinations require a medical professional with specialized training to undertake the process. This is a limitation for some locations in Kenya. Now, the really good thing in Kenya is that the Sexual Offences Act does support the use of DNA. This means police are able to obtain samples from suspects to compare against those who have been collected from crime scenes, and is able to corroborate what has occurred in the offence. This is able to then assist in the access to justice, because if there is a match between the DNA and what is collected from the person who the offence was committed against, it is able to help in the investigation, identification of the suspect, and prosecution of the perpetrator eventually. The DNA evidence kits are suitable for use with adolescent and adult female survivors who are reporting sexual violence, especially in the case of vaginal penetration. Now, in these cases, we do need to use the kits within 72 hours, because if we wait longer, the DNA is going to be degraded. Now, these kits do need to be used before other swabs are done with the survivor, such as testing for sexually transmitted infections. And this needs to be done after the DNA collection has occurred to ensure that there's no issues like contamination or reduction or removal of DNA to make it more difficult for analysis later on. Now, these kits still do need to be used in a healthcare setting under supervision, but it is up to the survivor whether they use the kits themselves to collect the samples under supervision, or if they elect for a medical professional to use the kit themselves. Now, you can see with the pictures on the screen, on the left-hand side we have a packaged version of the kit, and on the right-hand side you can see the kit unpackaged. In the kits we have a set of gloves to help with reduce issues of contamination, and then we have two tubes with swabs in them, one with a red cap, which is the vaginal swab, which is a shorter swab than the one that is found in the yellow capped tube. The yellow one is then used for the mouth, or also known as the buccal swab. You can also see here we have a breathable, tamper-evident evidence bag, and we're going to talk about all of these items in greater detail. In the bag is also instructions on how the kits work, and this includes pictures with the written instructions. Now, these kits are able to provide 3 key improvements to the current practice in Kenya. Firstly, they provide the option to survivors to do a self-examination under supervision. The second, the swabs are collected and can be air dried in the tubes that they're placed in, and they also air dry in the breathable evidence bags. And finally, the evidence bag itself is tamper evident evidence bag. So for the first improvement, the supervised self-examination, what we have here is that it provides the survivor with the option to collect their own sample, both the mouth swab and the vaginal swab. This means it can provide the survivor with some autonomy and can empower them through this process. This might make them feel more comfortable doing it and make it a little bit less intrusive. They do not require any specialized training or equipment to do it, and it can be safely conducted in low-resource clinics. Now, the survivor does have the option, if they do not feel comfortable doing this, to still have the medical professional to actually use the kit instead of the survivor. Here is an example of the mouth swab. We can see here on the left-hand side the yellow swab all in the tube packaged up. In the middle, you can see all the components broken down. And on the right-hand side, you can see a survivor using the swab. So what the survivor does is remove the swab from the tube, holding the yellow end, and rub the inside of their mouth on each side for about 5 seconds to collect a sample. And then this is used as a reference sample to compare against for the vaginal swab. The swab is then placed back into the tube and the black cap is removed, and this allows for the swab to air dry in the tube without having to be removed from the tube. Here, secondly, we have the vaginal swab. Again, here we can see on the left-hand side it's all packaged up. In the middle, we can see it broken down into all of its different components. And you can see that it is a shorter swab than the yellow mouth swab. So the survivor or the medical professional will take the red end of the tube and remove the swab with gloves on and insert it into the vaginal cavity and then rub against the sides of the vagina to collect a DNA swab. And you can see an illustration of this process on that right-hand side. Now, one of the really important things is about the red swab being shorter than the yellow mouth swab, and this means that it cannot be inserted too far, so the person is not going to hurt themselves through the process, and it can be inserted safely without going too far into the body. Now, what you see here is the breathable tamper-evident evidence bag. And the swabs on the right-hand side, you can see, have the black caps removed. Now, the black caps are an innovation as they can be removed from the tube, allowing the swabs to remain in the tube and continue to air dry without having to be placed elsewhere. DNA samples do need to be air dried, otherwise they will degrade, which means you cannot analyze it at a later stage. Now, these 2 tubes with the black caps removed are then placed into the breathable tamper-evident evidence bags, and I'm going to talk through this in greater detail in a moment, but basically those are placed in the bag and the evidence bag is sealed, and because of the design of the bag itself allows air into it, and it can continue to air dry in this bag in the tubes. Now, the second improvement that this kit provides is the air dry and breathable evidence bag. So currently the practice in Kenya, you can see in the picture on the right hand side, is that the swabs at some point when they're collected, and there can be a delay in this, the swabs are taken to the government chemist where they need to be analysed, but before they analyse they need to air dry them first. So what happens is the swabs are placed in this cupboard, they are removed from the tubes to air dry, and in this cupboard you can see that it's not secured. Now, there are a couple of key issues occurring here. We have the problem of potential contamination because we can see the close proximity between all the swabs in this cupboard. We have additional handling of the swabs, and this can contribute to contamination. The cupboards are not secured in any way, which increases the chances of tampering, and also the issue of human error, because someone could place one of the swabs into the wrong tube. Now, this is problematic to the evidence because it's really important that we do air dry the samples, but with the kits that we have, the swabs can remain in the tubes without having to be removed. And then they can also be placed in the evidence bag, which is a breathable tamper-evident bag. And so these swabs can continue to air dry in a secure way, which improves the integrity of the evidence. And these swabs can be kept in these bags for an indefinite period of time. The bags also do not need to be kept in refrigeration or placed in any other specialized location. They just need to be kept in a sort of cool room temperature condition to allow the swab to remain viable for testing. Now, another improvement to the process is that the swabs that we use, the actual sticks which the swabs are placed on, are plastic. You can see here in the picture on the right hand side that these swabs are actually using wooden sticks, and these can splinter, which can make things dangerous, especially when you're considering a vaginal self-examination. So the swabs that we have are the plastic ones, and they allow for bending without the risk of splintering in the self-examination. The third key improvement is the tamper-evident evidence bags, which you've seen a picture of already. Firstly, you'll notice that the bags have a lot of space on the front to write information about the case, so where it's moving, who's involved, that sort of information. Now the bags are able to provide critical improvement, which is the chain of custody, because what you can see here on the right hand side in the picture is these paper bags and envelopes that have samples in them being held in a refrigerator. Now these paper bags and envelopes, they offer no protection against tampering, and the evidence bags that we have, you cannot open them without there being clear tampering. It will actually say void if you try to remove the sticky that holds the bag together at the top. Also, because we have an air drying in the tubes and in the bag, it means that you do not have to place them in refrigeration, as you can see here. But because we have the air drying occurring in the bag, we have a clear chain of custody occurring as well. So we might even also see an improvement in the collection of samples by police to be taken to the government chemist for analysis, because the samples are not going to be degraded. Samples, and we've taken them to the government chemist, we need to analyze the samples to obtain the evidence to be used in the investigation and prosecution. Now, the analysis does need to be conducted by a qualified scientist, because they have to analyze, interpret, and present the DNA results to ensure that the DNA is presented in such a way that it makes sense to the investigators and to the court. Now, this is particularly important when we have cases of partial matches, complex mixed profiles, or in cases of secondary transfer. And these are some examples of some more complicated forms of DNA analysis. And we also need to make sure we don't have issues of potential contamination. So when we're doing analysis, we need to make sure that the laboratory itself is certified and is using appropriately certified equipment. And we need to make sure that there is a level of independence between the laboratory and the investigators, so that we don't have any influence in the write-up of the results. When we're going through the process of analysis, we are extracting DNA, we are measuring it, we are amplifying it, and then we need to analyze and interpret the results to see whether or not, in the case, we have a match. Once we have identified the survivor's DNA from the mouth reference sample collected, the remaining DNA profile from the vaginal swab is able to provide a profile of who the perpetrator or perpetrators are. Now, what you can see here is an example of a single source DNA sample. So this is when there is only one contributor to the sample we are analyzing. So for example, if you do a mouth swab, you would generally expect there to be only one DNA sample present. Now, the way in which samples are presented can differ, and what you can see on the screen is just one example of how you can present this in a report. So what we see here at the top is the evidence sample, and we can see these peaks here along the page. And basically these peaks are called an allele, and together they make up a loci. So if we look at the top here, we can see there are 2 peaks, then we have a space, we have another 2 peaks, then 1 peak, and then another 2 peaks. Each of these 2 peaks make up a loci. So along the top there, you actually have 4 loci. What you can see below is another sample, and when we look visually at the top line and the bottom line between the evidence sample and the suspect sample, we can see that there is a match between the 2 profiles available. And that would tell us that the sample we have matches against the other profile. And if we know who the suspect is, then we're able to identify them. To explain this in a little bit more detail, you can see here the yellow arrows demonstrating individual loci. Some loci have 1 or 2 peaks, which are called alleles. With the green arrows, you can see demonstrated at the bottom profile, the first loci has 2 alleles, and then later on you have a loci with only 1 allele. And this just means that the genetic markers that the individual has inherited from their parents is the same, and so there is only 1 peak, or what we call an allele. Whereas when there are 2 alleles, the person has inherited 2 genetic markers to make up who they are. So what does a match actually mean? It means that we have a reference sample and we are comparing it to the trace and we have collected, such as from a vaginal swab or from a crime scene. And when we have these two, we're able to exclude or include a suspect. Now we need to make a match against a number of different markers, which we call loci, and we are usually looking at using 13 loci to identify an individual. The less loci you use, so on the previous slide we saw 4 loci, this would not be appropriate in a case in an investigation or to go to court because it is so little. What we want to see is 13 or more loci for there to be what we consider there to be a good match. If we have a partial match or a weak reading, we might have less loci available to us as a consequence, and that would be reflected in the report and talk about the consequences of what this match means. When we have a suspect's DNA, what we do is place them on a DNA database and then we compare them against crime scene samples that we've collected. And this means that we can have a bank of individuals where it is legally, appropriately collected to identify persons unknown in a case we are working on. If there is no match in the case when we're comparing against the DNA database, then at that point in time the person is just unknown. Now, if we have some idea of who this person might be, then the police can collect a sample and have it analysed and placed on the database, and then we're able to make a comparison to see whether or not there is a match to identify this person as the contributor. If you do not know who the suspect is, then we cannot collect their DNA as a reference sample, and then until such time that their DNA is placed on the database, then that person remains unknown. So databases are often made up of a number of subset databases. So we have firstly that for convicted offenders, and it's important to have them on file, especially when we're dealing with dangerous offenders. And often in many countries, these persons will remain on a database for an indefinite period of time. We then have those who are arrested or who are suspects, and quite often if they go on not to be charged or not convicted of an offence, then they will be removed from the database. Then we have a database which would be for unknown, and this is often crime scene samples or samples collected from survivors. And then we have a database which is for missing persons and relatives of missing persons. And this means that if we find remains, we can compare against the database. We collect the relatives of missing persons DNA because we may not actually have that missing person's DNA on file, and through the use of familial DNA, where siblings, cousins and parents share genetic markers with each other, we're able to use that DNA to make a match on that information. And then there may be another database that would have general and unidentified remains which would remain there on file. Now, when we've got this information and the police have used it in an investigation and we're going to court, we need to decide on the admissibility of that information. When we are placing someone on the database, it's really important that what has been done is lawful. So we need to make sure that there is a court order and reasonable grounds or suspicion to collect that person's DNA. So in Kenya, you cannot just go out and collect anybody's DNA and place them on the database, because the Kenyan courts have found this to be unlawful. We also need to be careful in situations when we're dealing with vulnerable suspects, such as those with mental illness or capacity issues. This also includes children who are vulnerable because they're under the age of consent. A person can voluntarily provide their DNA to be analysed without a court order, but we need to make sure that that person has provided informed consent. If the DNA has been unlawfully obtained, then we need to decide whether or not, in that situation, it is probative enough to outweigh the prejudicial value of the evidence, especially if there is a match between the suspect and the crime scene information. When we're deciding on the admissibility of the evidence, we also need to decide whether there has been a clear chain of custody. If there hasn't been a clear chain of custody, then that undermines the integrity of the evidence, and this means that it may not be appropriate to be used in the case, which is why it's so important that we have this chain of custody and this issue is rectified in Kenya. We also need to make sure that the expert that is talking in the case, who is presenting the results, is someone who is suitably qualified. When we have our DNA evidence, the chain of custody is really important. We need to have integrity at each step of the process. If we don't have that, then it undermines the evidentiary value in the case. The clear chain of custody is from the time that the sample was collected from the survivor up until it gets to the laboratory at the government chemist. We then need to continue this chain of custody even once it's been analysed, because we may have cases where we might need to go back and reanalyse that evidence. We need to make sure that there is no contamination, no mix-up of samples, or tampering. That's why the evidence bags, which are tamper evident, are really important, so you can tell whether or not someone has tampered with it, and you can call for a chain of custody to be explained and supported with documentation from the police and the laboratory through their procedures and the forms that you would be expecting that they would fill in along the way to trace where that evidence has gone. When we have a suitably qualified expert, they are coming into court to present the evidence to a judge as to what that evidence means and what it includes. So generally speaking, you would expect an expert in relation to forensic evidence, such as DNA, to have some sort of bachelor's degree at a minimum in a relevant discipline, because then they would have expertise that aligns with their education. Often you will see relevant organisational training and service in the industry, but because it is something you need to maintain as a qualification to have an awareness of the laboratory standards. So expert evidence in Kenya, you need to have an opinion of an expert who is knowledgeable in the area of the analysis, and this would be someone such as a government chemist who has that degree and also that relevant training and service in the industry. It is important that the expert that presents the evidence at court is also the one that analysed the information, and that those samples and a suitably competent person testify and inform the court about those conclusions. It is then up to the court to decide the value of that evidence in relation to that case. Once it is decided that we have an appropriate expert who is presenting the results in court, there are still a number of things that the court needs to keep in mind. There are a number of statistical models on which DNA results can be presented, which is why we need someone with the expertise to present these results. The rarity and the potential to match against a profile is calculated using these models based on statistical rules. The ways in which these rules are established and adjusted is developed through what we know about the population's genetics. We collect a number of persons within the community, their DNA, and then we compare against that to come up with a statistical likelihood as to whether or not the person could be a contributor or be excluded as a contributor to the sample. And this is why the work that has been undertaken by the University of Leicester and the Kenyan University is particularly important, because they have worked together to establish a large YSTR reference database for Kenya. And this actually assists the government chemists in the interpretation of the DNA results in the context of a Kenyan population genetics specifically. Because if a population's genetics are unique to that area, then the information needs to reflect that. So if we were to compare a DNA sample collected from Kenya against a UK database, we're not going to get the same statistical results. And this could have an impact on how those results are presented and understood in court. It is also really important for an expert to appropriately present the DNA results to court, because there are a number of different ways in which you can present the information. And we need to make sure that we're not falling into the traps of a prosecutor fallacy. Because when we present evidence in a particular way, for example, the probability of them being from a potential contributor or excluded as a contributor, can be influenced in the way in which the information and the evidence is actually interpreted and presented at court. We've got a couple of scenarios here to talk about in relation to contamination and secondary transfer. So in this scenario, we've got the issue of contamination. So you, as a security guard, have legitimate access to a building before a stabbing took place there. The police investigators wore plastic gloves to recover a knife from the crime scene. But before they went into the room, they touched the door handle that you had also previously touched. As a result, your DNA was accidentally transferred to the knife, and this is an example of contamination. Now, this is actually based off the facts of a real case, which actually happened and led to a wrongful conviction and led to the conviction then being overturned. It had some very serious consequences, which included having to shut down the laboratory in the jurisdiction in which it occurred. The second example is that of secondary transfer. A man is attacked by someone wearing a mask while walking home from a party. Your DNA is found on the victim's hands. You were also at the party and had no direct contact with the victim, but you both poured a glass of wine from the same bottle. This caused your DNA to be transferred to their hands. The point of this is to illustrate how easy it is to transfer DNA between persons who have touched the same item. This is because it is now possible to obtain DNA from very small samples. It is important that we're aware of these factors when analysing the information and putting it into context of the broader investigation. And why it is also important that we do not just rely on DNA evidence, but also collect all the other evidence related to the case and the investigation. Now, if you would like to see our video, which goes into much more detail about the kits and how they're used in the healthcare settings, then you may go to this link to watch the video. And it just goes into much more detail about using it in practice. If you have any questions or comments, please direct them to the project lead, Professor Lisa Smith at the University of Leicester, and she is quite happy to answer any questions about these kits. Finally, we have some references here if you would like to do any additional reading, and we thank you for your time.